Hi, myself Mohd Ayan, and I'm a third year undergraduate at the Faculty of Law, Jamia Millia Islamia, New Delhi. In this session, I'm going to introspect into the new CSR regime that a recent amendment to Section 135 of the Companies Act. Starting with the introduction, the Companies Amendment Acts of 2019 and 2020 resulted in some major changes in the CSR provision under Section 135 of the Companies Act. To provide for the notified changes, the Ministry of Corporate Affairs (MCA) had released the Draft Companies Corporate Social Responsibility Policy Amendment Rules in March 2020, inviting public comments. Recently, on 22nd January 2021, the MCA finally issued the company's Corporate Social Responsibility Policy Amendment Rules, which are new rules giving effect to the changes introduced in CSR by the Companies Amendment Act of 2019 and 2020. List of activities not covered under the CSR. Rule 2, Clause 1, Subclause D prescribes a list of activities that shall not fall within the ambit of CSR. This list includes, firstly, any activity that the company does in its original course. However, exceptions include companies undertaking research and development activities for COVID-19 related activities like vaccines, drugs, and medical devices. Secondly, any activity done in a foreign territory apart from training of sports personnel representing India in a national or international competitions. Donation of any amount to political parties under Section 182 of the Companies Act. Thirdly, activities which benefits employees of the company as per Section 2 Clause K of Code on Wages 2019. Fourthly, activities which the companies support on a sponsorship basis for deriving marketing benefits or goods and services. At last, any activity done in order to fulfill the statutory obligation under any law. Appointment of implementing partners. Rule 4 Clause 1 prescribes a list of implementing partners that a company may appoint by performing CSR functions. This list includes Section 8 of Companies Act, that is, a registered public trust, a registered society, etc. Only those entities listed under Rule 4 Clause 1 may be appointed as implementing partners of the company. From April 1, 2021, every entity designated as an implementing partner must register with the central government. Obligations of the Board and CSR Committee. The new CSR rules placed additional responsibilities on the Board and the CSR Committee to monitor, evaluate, and report CSR activities. Rule 4 Clause 5 stipulates that the Board must ensure the CSR funds are used in an approved manner. Under Rule 4 Clause 6, in case of an ongoing project, the Board must monitor the implementation of the project following the approved timeline and make changes for the successful implementation of the project. Rule 2021 of Rule 5 Clause 2, where it is specified that the CSR committee shall formulate and recommend an annual plan to the board. This annual plan, as suggested by the CSR committee, includes list of approved CSR project, manner of execution of CSR project, implementation schedules and modalities for fund utilization, monitoring, reporting and mechanism, and at last, impact assessment. CSR expenditures must be set off. By the Companies Act Amendment 2020, a provision has been added to Section 135 Clause 5, which allows a company to set off the surplus amount of CSR used in a financial year for few years of financial future years, determined by regulations. Under Rule 7 Clause 3, the surplus amount of the CSR must be set off within the next 3 financial years. Rule 7, Clause 3 sets two preconditions to comply with before the excess CSR amount is set off. The excess CSR amount should not include any surplus generated out of the CSR activities. The board should pass a resolution permitting the set off. Impact assessment of the new regime. Under Rule 8, Clause 3, Subclause A, every company which is obliged to spend a minimum amount of CSR of 10 crore rupees or more must conduct an impact assessment through an independent agency on those CSR projects that have an outlay of rupees 1 crore or more. Impact assessment can only be done after 1 year has elapsed from the completion of the date of project. These impact assessment must be included in the annual CSR report and reported to the board. Under Rule 8, Clause 3, Subclause C, impact assessment regarding expenditure regarding corporate social responsibilities obligation for that particular financial year shall not exceed of the total cost of the CSR expenditure. Case law on point. In Manohar Lal Sharma versus the Principal Secretary 2012, the Supreme Court of India emphasized on the contribution towards corporate social responsibility and socio-economic development of the country. Coming down to the final comments, along with Section 135 of the Act, these new CSR rules form a stringent legal framework for performing CSR functions in India. To ensure compliance with the new legal framework, companies must keep detailed CSR committee meetings, CSR fund allocations, and projects undertaken through partners. The CSR mandate under Section 135 was initially established on the principle of compliance, in which a company may perform CSR functions of the state or reasons for the failure to spend CSR value. Parliament may consider compliance with Section 135 to be voluntary and not compulsory.